State of Michigan versus Brandon Scott Berry, 23-198 FY. People versus Erin Buchholz, 23-199 FY. People versus Mason Pechette, 23-200 FY. Mr. Berry is here with his lawyer, Mr. Morosky. Mr. Pechette is here with Mr. Hallman, and Ms. Buchholz is here with Mr. Allen. The people are represented by Mr. Pahani, who's also in the courtroom. The matter is before the court on the people's motion to reopen proofs. And Mr. Pahani, are you ready to proceed at this time?
We are, Your Honor.
Mr. Hallman?
We're ready, Your
Mr.
Honor.
Allen?
Ready, Your Honor.
Mr. Morosky?
Yes, Your Honor.
You may call your witness, Mr. Pahani.
Thank you, Your Honor. The people call Walter Salins to the stand.
Mr. Salins, if you make your way to the witness bar, please. Step and raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth? I do. Thank you. Make yourself comfortable. Speak up, please.
Good afternoon, sir. Can you please state your name for the record?
Walter J. Salins.
Mr. Salins, how are you employed?
I'm an attorney here in Madison.
And how long have you been in practice?
35 years.
And do you have any specific practice areas in which you specialize?
Not in a small town, no. I used to do criminal work, criminal appointment work until I'm the DOAC now. I do real estate transactions, real estate litigation, probate real estate, probate litigation, civil litigation, corporate work.
Safe to say a little bit of everything.
Yes.
Have you ever had the opportunity to represent Allison Majeski?
Yes, I have.
And what was the purpose of your representation for Ms. Majeski?
Ms. Majeski had contacted me to represent her because she had received a letter from Attorney Kyle O'Mara regarding a home that she had purchased with Mr. Berry.
And is it safe to say that you ultimately met with Ms. Majeski?
Yes.
And what was your understanding then, after your review of her case, of the ownership of that home?
Based upon the deed that had been prepared, the two of them own the home as joint tenants with full rights of survivorship.
And was there any cause of action filed at that point, or where were you at when she first met with you?
She had received a letter from Attorney Kyle O'Mara in January of 2022, and in that letter he was requesting that personal property that was owned by Mr. Berry be returned to him, and he wanted a partition of the property, he wanted her, to negotiate a settlement, to sell the property, purchase the property, or if he couldn't get that, then he would petition for partition of the property.
And so when did your discussions with Mr. O'Mara begin with reference to this case?
I responded to him in a letter in February of 2022.
May I approach the witness, Your Honor?
Yes.
Mr. Salins, I'm showing you what's been marked as People's Proposed Exhibit number 7. Do you recognize that document?
Yes, that's a photocopy of the letter that I sent to Mr. O'Mara.
And you were the author of that letter?
Yes, that's my signature.
And is that photocopy a fair and accurate representation of the original letter that you sent to Mr. O'Mara?
Yes.
People move to the admission of Proposed Exhibit 7.
Objection about here, Mr. Morosky?
No, Your Honor. No objection at this time, Your Honor. Thank you.
Mr. Allen?
No objection, Your Honor.
Exhibit 7 is admitted.
And Mr. Salins, what were the from your perspective, what were the apparent goals of litigation for Mr. Berry in this case?
The ultimate goal, or when we started out?
When you started out?
When we started out, it was my understanding from negotiating with Mr. O'Mara that Mr. Berry just wished to be purchased, his interest be purchased.
And what were the goals of your client?
She didn't want to be an owner with him anymore, and since the way it was titled, that's the only way she could take his name off was to buy him out.
And so did Mr. Berry, in your experience, did he want to regain possession of the home?
Every discussion I had in the letters going back and forth between myself and Mr. O'Mara, it was my understanding he wanted to be bought out.
And during the pendency of this litigation or these discussions with Mr. O'Mara, did you have contact with him, Mr. O'Mara, regarding Brandon Berry not entering the property?
Yes.
And is that outlined in that letter that's now been admitted as People's 7?
Yes, it would be, if I could explain.
Please.
The second paragraph on page 2, the reason why I coached it in that manner was because the original letter that Mr. O'Mara wrote to Ms. Pechette contended that she had made derogatory comments about him in criminal matters and things, and that's why it was written back that way.
Now, did Mr. O'Mara respond to your letter of, I believe that's February 2nd?
Yes, we have many letters going back.
Mr. Salins, I'm showing you what's been
Hang on
marked.
a second. This is the 2:20 PM National Alert,
Yeah.
so just wait a second, off the record. I think that's it. Go back on the record.
Mr. Salins, I'm showing you what's been marked as People's Proposed Exhibit 8. Do you recognize that document?
Yes.
And what is that?
That is the response to my letter of February 2nd from Kyle O'Mara.
And is that a fair and accurate representation of the original that you received from Mr. O'Mara?
It looks like it, yes.
People move for the admission of Proposed Exhibit 8.
Objection over here, Mr. Tronsky.
No objection, Your Honor.
No objection. Thank you.
Mr. Allen.
Objection, Your Honor.
Proposed exhibit 8 is admitted.
Now, in addition to these letters back and forth, did you have any other kind of contact with Mr. O'Mara?
I remember having a conversation with Mr. O'Mara, whether it was telephone or over here at the courthouse about this case.
What did that entail?
It was regarding the contact between the two parties, because as my letter states in Exhibit 7, my client was going out of town, and I didn't want him going into the home or having any problems with my client or anyone else.
And was it your understanding after that conversation that Mr. O'Mara understood your wishes?
Yes.
And did he disagree with anything that you had asked for as far as Mr. Berry not returning to the home? Or did he take issue with anything?
He didn't take issue.
Now, is it fair to say that no written order was ever entered with Mr. O'Mara as to a restraining order or a no contact order or any kind of written order filed with the court?
That's correct.
Do you know why that is, from your perspective?
Two things. One,
Your Honor, I'm going to object to any testimony about why Mr. O'Mara may or may have received the comments that Mr. Salins testified to.
I agree.
Speculation.
I agree with that statement, but if you need to reformulate a question or not.
The question was from Mr. Salin's perspective is why was there no written order entered between the parties? He can certainly answer from his own
This
perspective.
testifies to his belief as to why there was no written order.
Actually, from a legal standpoint, as a lawyer, one, you can't enter an order when there's no file thing open. No lawsuit had ever been filed, so no order can be entered. Judge can't execute something that's not there. Second, my client was in the home. Mr. Berry had left the home. We didn't feel it was necessary to have a PPO or any of those orders entered.
Now, to your understanding, as the case progressed, or as the talks or litigation progressed, was there any further contact between your client and Mr. Berry?
There was one contact in June of 2022.
And did you send correspondence to Mr. O'Mara regarding that contact?
Yes.
Your Honor, I don't object to the admission of this.
I haven't moved for the admission.
Go ahead.
I'm showing you what's been marked as People's Proposed Exhibit 9. Do you recognize that? It's a multi-page document, if you wouldn't mind reviewing it.
I reviewed it.
Do you recognize that document?
Yes.
Can you explain what it is?
The part of the document is an email that I sent on to Mr. O'Mara. Other is photographs and an email from Ms. Majeski that she had sent to me.
And is that a fair and accurate representation of the correspondence that you had with Mr. O'Mara?
Yes.
The people will move for the admission. Proposed Exhibit 9.
Mr. Morosky?
No objection at this time,
No, that's not.
Mr.
Your
Elmore?
Honor, there's hearsay in the document itself, reporting that Mr. Berry is the person behind these things, and that's hearsay. Jesse's not here to testify about that.
Is it in the letter from, is it in the letter portion from Mr. Salins? Or is it in the portion?
It's part of the
prepared by
attachment, Your Honor.
Ms. Majeski?
And, Your Honor, I believe it's part of the attachment, and it's also presumed in the body of the email itself.
Your Honor, this exhibit isn't being offered as proof of the matter asserted. The matter asserted here is, did Mr. Salins send an email to Mr. O'Mara about purported contact between an individual, allegedly Mr. Berry, and Ms. Majeski? Did he follow up with Mr. O'Mara? He testified that he did, and this exhibit is indicative of that. This is not for the proof of the matter asserted, in that Mr. Berry was indeed the person who is accused, so there is no hearsay.
Then it's irrelevant, Your Honor, that my objection is on relevance.
It's relevant because Mr. Salins has just testified that he made contact with Mr. O'Mara about a purported contact between Mr. Berry and Ms. Majeski.
Your Honor, you're trying to establish that there was some kind of contact between Mr. Berry and Ms. Majeski. The appropriate person to put on the stand for that is Ms. Majeski. Mr. Salins cannot testify about anything involving contact between Mr. Berry and Ms. Majeski. He wasn't there, he's not a recipient witness, and it shouldn't be admitted for that reason.
Ms. Majeski's already testified to that at the first part of this preliminary examination.
The thrust of the exhibit is to inform the court about this correspondence between Mr. Salins and Mr. O'Mara, correct?
It is, Your Honor.
All right. The objection's overruled, but I will give the attachment whatever weight is appropriate. Go ahead.
Now, Mr. Salins, is it safe to say, or fair to say, that Mr. Berry's representation changed during the course of this litigation?
Yes, he went from Mr. O'Mara to himself to Mr. Rooney.
And did you begin discussions with Mr. Rooney about this case?
Yes, in August of 2022.
And Did you have any similar conversations with Mr. Rooney about there being no contact between Ms. Majeski and his client, Mr. Berry?
Yes.
Did he seem to understand what you were looking for when you had this conversation?
Calls for speculation, Your Honor.
I believe.
How does it affect Ms. Buchholz? Isn't that really Mr. Morosky's objection, as I think about it? I mean,
Your Honor, my client's rights to be on the property on the night of April 28th are derivative of Mr. Berry's. She was an invitee of Mr. Berry, a joint tenant in the property. So,
Your Honor,
you know,
made it very.
hang on. You know, I've heard that, but I don't believe there's any evidence that that actually is the case, but I'll be reviewing the evidence. I mean, maybe on the body cam or something, there's some mention about that, but I'm not clear. I'm going to rephrase it. I'm not clear that there is evidence in this case that that Ms. Buchholz was in fact an invitee on the property. I'm just saying that because that's my understanding. Go ahead.
Your Honor made it clear during the people's motion to reopen the proofs that this exam would be reopened with specifically to Mr. Berry, that the other attorneys in attendance would certainly be able to ask questions. But Mr. Morosky is Mr. Berry's counsel, and we would take the same position.
Your Honor, the rules of evidence apply in this hearing to my client as well as they do to Mr. Berry and Mr. Pechette.
And Mr. Morosky is perfectly
Don't
capable of
interrupt. Don't
exercising.
interrupt. Go ahead, Mr. Allen.
Your Honor, if the question on the table is asking Mr. Salins to speculate about what Mr. Rooney believed, it is an inappropriate question because Mr. Salins is not living in Mr. Rooney's head. Mr. Rooney was here on August 18th, and that question could have been posed to Mr. Rooney at that time.
I didn't get that connotation from the question. I agree with what you're saying, but I didn't interpret the question that way.
I didn't ask the question in that manner, Your Honor.
Right.
My question for Mr. Salins is, did he believe that there was an agreement with Mr. Rooney after this conversation that Mr. Berry would not contact Ms. Majeski?
I'm going to object to that because it's irrelevant, Your Honor.
I'm going to object for standing,
It's
Your Honor,
irrelevant,
because
Your Honor.
he doesn't have it.
Your Honor,
If there's a standing issue, also, the objection's overruled because I think that's a present sense impression at the time that Mr. Salins had this apparent agreement. I haven't heard the answer yet. Is the answer?
He has
Go
not
ahead
had
and
the
answer the
opportunity
question.
to answer.
Answer the question.
It was my understanding through my conversation with Mr. Rooney that he understood that his client would not go on the property, and I was assured of that.
So that's your objection right there. The objection's overruled because I believe it is a present sense impression based on the testimony of this witness. Go ahead.
Did Mr. Berry's litigation goals change after he retained new counsel?
When he retained Mr. Rooney, it was still to be a partition action because of joint tenancy, and that the correspondence or any communication with Mr. Rooney was to buy him out.
So was there any discussion of regaining possession of the home on Mr. Berry's behalf by Mr. Rooney?
No, he always wanted to be bought out.
Did your client and Mr. Berry ultimately reach a settlement in this matter?
Yes, just a while ago.
And did Mr. Berry regain possession of the home as a result of that settlement?
No, he was bought out.
I think I have nothing further at this time, Your Honor.
Mr. Morosky?
Thank you, Your Honor. May I question the witness from the table here?
Yes, you may.
Thank you.
You may be seated too if you like.
All right, thank you. Mr. Salins, you represented Ms. Majeski during the civil issue,
Yes.
and it started out with representation by Mr. O'Mara or Mr. Berry.
It started out with Mr. O'Mara, then he was by himself for a while, and then he went to Mr. Rooney.
Do you recall how long he was representing himself?
I couldn't give you an exact time, maybe a month, because I met with him and Allison Majeski one time.
And it was your testimony that it was Mr. Berry's interest in buying out the home, but that's not true, is it? Because he also made offers to buy Ms. Majeski out.
21st he did, yes.
And as the,
The first letter that I received from Mr. O'Mara stated, yes, he would pay my client, I believe, $34,500, somewhere in that area, to purchase her interest, and after that, he was just willing to be bought.
but that's how the litigation started. Mr. Berry was willing to buy her out at that time.
Before any complaint was filed, yes.
And then the litigation switched to Mr. Berry wanting to buy that property. There was conversation about him wanting to buy the property.
Just in the first letter. If I may, we went back and forth with offers back and forth between the two of us.
Right, but Mr. Berry at some point wanted to take ownership of the home from this. All right, thank you. And when you had stated that they were joint tenants, you meant that they had a joint tenants with rights of survivorship, ownership.
That's what the deed said, yes.
And do you recall any of the conversations you had with Mr. Berry when he was in poker?
There was one conversation, I believe, with Allison, him and I together, and to try and resolve the matter. And that didn't work out.
And do you recall, are there any emails going back and forth between yourself and Mr. Berry?
No, I don't recall any email from him.
And do you recall when he hired Mr. Rooney?
I don't know when he hired Mr. Rooney. The only time I know that he was represented by Mr. Rooney was when I was served with the complaint for partition of the property.
And after that complaint was filed, there was discussion about Mr. Berry buying out Ms. Majeski.
Most of the conversation was her buying him out.
Right, but not all of the conversation.
Yeah, 95% of it was because they had come to an agreement, not a figure. Then Mr. Berry was not satisfied that he wanted it done in 10 days. And when I explained that to him and Mr. Rooney, that a bank can't do a refinancing of a home with an appraisal in 10 days, then the agreement fell apart and went back to negotiating until we came to the court for a motion for summary disposition.
And do you recall when that was?
What was?
The motion for summary disposition.
April of this year, I believe 23rd or 27th of this year.
And there was no ruling on that summary disposition?
If I may explain? No, there wasn't a ruling because the court didn't want to make a ruling.
I have no further questions, Your Honor.
Mr. Holman?
Thank you. Mr. Salem, my name is Zach Hallman. I represent I'm sorry.
No, that's fine. Counsel, People's Exhibit 3, I have 9. Exhibit 9, did you move to admit that, Mr. Honey?
I did, Your Honor, and the court admitted it
All right.
conditionally, I believe, with weight,
Is it-
appropriate weight given to
That's
the
correct.
attachments for the courts.
9 is admitted. Sorry to interrupt you, Mr. Holman.
Oh, that's all right. Thank you, Judge. Mr. Salins, I represent Mr. Pechette, who you don't know at all. Is that correct?
That's correct. Never met him.
When did you form the agreement that you referenced to Mr. Pahani with Mr. Rooney?
Shortly after Mr. Rooney filed the complaint, because he informed me that he was then retained by Mr. Berry, Mr. Rooney came over and said that he was going to be filing the complaint.
Do you remember when that was?
It would be probably in the first week of August, somewhere in there, shortly after I got the complaint, around that time.
Of 2022?
And yes.
If, as best as you can remember.
Yes.
And the conversation happened over the phone or in person or
In my
through what
office.
meeting?
He walked into my office. He's
Mr.
2 doors down from me, so he walked into my office.
And you had a conversation about this matter?
Yes.
The two of you,
Yeah, it wasn't the only place we had a conversation about this case.
I'm sorry, that was,
We had conversations, see, I have an office here in this courthouse.
okay, I
I
understand.
have an office across the street.
Sure.
Mr. Rooney would come to my office upstairs and discuss his case, and over at my office over on High Street, 2 doors down from me.
Okay, so you had many conversations
Yes.
about this case.
Yes.
But we're talking just right now about the agreement that you referenced during examination that you formed with him.
It would be in my office.
It was, that conversation
In my office or his office, one
was in your office?
Yes.
Was that the only conversation that you had that was regarding an agreement
No.
of, if you,
Well, I know the exact date, the date of the summary disposition motion in the judge's chambers.
I'm sorry, I'm not even, I haven't posed a question.
Oh, I thought, I'm sorry.
I'm wondering about that initial conversation that you had with Mr. Rooney in your office. What was that agreement?
I had informed him that I had spoken to Mr. O'Meara prior to keep these two apart,
Okay,
and that there was no written order. And I asked at that time, could we get a written order, since now he's filing a complaint, mutual restraining order against both of them from, the standard one, harassing, ill-treating, going upon the property, molesting, talking to each other, internet contact, all of that stuff.
and what was Mr. Rooney's response?
He said we didn't need it.
And you were satisfied by what he said to you?
I was satisfied that he assured me that we wouldn't need it, because according to him, there was no problem. There was one.
And that problem was before he got involved?
Yes, sir.
And before he got involved, when there was an issue, did you ever file a PPO on your client's behalf?
No, because my client had property.
Thank you. After he got involved, did you ever feel it necessary to file a PPO on behalf of your client against Mr. Berry?
No.
Okay. And when you formed, when you agreed with Mr. Rooney that, let's scratch that question. What were the actual terms of your agreement with Mr. Rooney?
I had just asked that his client continue to stay away and not have any contact with Mr. Jeske. Stay away from the house, no, I have no contact with him.
You say stay away from the house,
Yes, sir.
but is it true that your agreement, however the agreement was formed, was never reduced to writing?
Correct.
Wasn't your agreement that the parties would stay away from each other, or that Mr. Berry would stay away from Ms. Majeski?
No, stay away from the house also.
Wouldn't you have thought it important at that time, considering the history of the parties, to reduce that agreement to writing?
They didn't have any abusive history prior to that time. There was no history.
So you didn't think it was important?
No. There was no abusive behavior, nothing. There was no contact between the two of them between February and June.
And again, Mr. Salins, I have all the respect for your practice and for your conduct in this case. You thought it important enough to approach Mr. Rooney regarding the parties staying away from each other, and you had more than one conversation about it.
Right.
Is it true that on the affidavit that you signed for Mr. Pahani in this matter, there's no mention of an agreement for the parties to stay away from, or for Mr. Berry to stay away from the property?
I don't remember the exact language. I can look at it.
Okay.
Refresh my memory.
You mentioned the other instance that you mentioned in April of, I
Yes,
believe,
the
right,
motion.
the motion.
Mhm.
That Are you referencing an order? Now, was this assurance done on the record?
No, in the judge's chambers.
Okay, so the conversation was between you and Mr. Rooney and His Honor,
In the presence of Judge Pro, yes.
and nobody else?
No, it's in his chambers.
And again, did you reduce this agreement to writing in an email?
No,
In any writing, even to your client?
no.
Okay. On April 28th of 2022, was there, as that you are aware of, any order preventing Mr. Berry from entering the house that at that time he still owned?
There's no
With-
written order.
My question was there any order?
No written order.
There was no written order or any order, was there?
That's the only kind of order there is.
Well, then that's my question. Was there any order? And I was only confused by your answer.
No, there's no
You're saying-
written order. There's just
Thank
an
you,
order.
thank you. If the roles were reversed and you were representing Mr. Berry in this matter,
Mhm.
would you have advised him on April 28, 2022, that he legally could not enter the property?
Objection, that calls for speculation.
Overruled. Go ahead.
If I was representing Mr. Berry on April 28th, and I had been representing him since January 2022, and the conversations had been coming back and forth, if Mr. O'Mara had asked me to keep him away, and I told him to do that, I would advise him to stay away.
That's actually not exactly my question. I do appreciate it, but I'm going to re-ask. If the roles were reversed and you were representing Mr. Berry, I'm not asking you to consider what time you began representing him, maybe April 27th. On April 28th, would you have advised him that legally he could not enter the property?
Objection, this is asked and answered. This is a hypothetical that would require speculation. Mr. Salins has answered in that if the roles were identically reversed and he had been in the identical situation, he's given his answer to the question. Now we're talking in hypotheticals that involve speculation.
The objection's overruled because it's a legitimate hypothetical, and the key word to the question is legally able to be on the property. So
That requires Mr. Salins.
we're not talking about the agreement, we're talking about advice as to whether it's legal for Mr. Berry to be on the property as framework in the question.
Then, Your Honor, the people's objection is to relevance because Mr. Salins' legal opinion in this hypothetical situation is not relevant to the legal opinion that the court has to make in this particular ruling.
Objection's overruled, go ahead.
Do you want me to re-ask the question?
No.
Okay.
Legally, he had just as much right to go into the home as a joint tenant.
No further questions.
Mr. Allen, questions?
I don't believe I have any questions for Mr. Salins.
Very well, thank you. Redirect?
No redirect, Your Honor.
Thank you, Mr. Salins, you can step forward for your attendance. Any other proofs, Mr. Bahani?
Yes, Your Honor. People call Sergeant Brad Skorzeski to the stand.
solemnly swear or affirm that the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth? I do. Thank you. Make yourself comfortable. Please speak up so we can hear. Thank you.
Can you please state your name for the record and spell your last name for the court recorder?
Bradley Strozeski, Strozeski.
And how are you employed, sir?
With the Huron County Sheriff's Department.
And how long have you been employed in that capacity?
Approximately 16 years.
And what is your position with the Sheriff's Department now?
Sergeant.
And what was your position back on February 25th of 2022?
Road deputy.
Okay. And so is it fair to say that your standard assignment would have been road patrol?
Correct.
Okay. And were you working in your capacity as a road patrol deputy on February 25th of 2022 at about 10 p.m.?
Yes.
And did you have occasion to respond to a complaint at 1927 East Kendi Road in Dwight Township, Huron County?
I did.
What was the nature of that complaint, Sergeant?
Regarding a well-being check for dogs.
And did you make that scene?
Pardon?
Did you go to the scene? Did you go to 1927 East Kendi Road?
I did.
And who did you find once you arrived?
I believe it was Jake Eisler.
Okay. And who was your complaining witness in that case, or your complainant, I should say?
Mr. Berry.
Okay. And did you speak to him by telephone or in person?
By phone.
Okay. And what was, you said you were there for a welfare check for dogs. What was his concern?
Yeah, I don't know, check the relevance. I mean, what does this have to do with the
Or
court?
give me the opportunity to lay some foundation. We'll have relevance in a moment.
Checks are taken under advisement. Go ahead.
What was the nature of Mr. Berry's concerns?
He was concerned that the dogs weren't being fed or watered properly.
And what did he specifically, if anything, ask you?
He asked me if he could go onto the property and check on them himself.
Okay. And did he give you any background information as to why he wouldn't be able to go onto that property?
He did.
And what was it? What did he tell you?
We spoke for a bit on the phone, and he mentioned that.
Aaron, I'm going to object. We don't know when this conversation took place.
You just
The
laid
date
the
was,
foundation.
the date was 2/25/22. The objections overruled. Mr. Morosky, go ahead.
Would you continue, Sergeant Strzeski? What did he tell you?
We spoke about his whole experience with the mortgage, him paying the mortgage, and that he received a letter from Mr. Salins telling him not to go onto the property. I also advised him it wouldn't be in his best interest to go onto the property. I advised him it was a civil matter.
But you did not give him a legal order not to enter the property, correct?
No.
Okay, thank you. I have nothing further.
Cross-examination, Mr. Morosky.
No, one moment, Your Honor. Do you remember the whole part of that conversation with Mr. Berry?
No,
And it was quite a long time ago.
it was.
So there's parts that are obviously missing to that conversation. Meaning, I mean, what you stated wasn't verbatim.
Correct.
And was there a police report filed in that matter?
There was.
Do you recall when it was produced or handed over to the, your supervisor or whoever?
I do not.
No further questions, Your Honor.
Your Honor, I'll object if the defense counsel would like to refresh the witness's recollection with the report that was provided through discovery. I can certainly let him borrow a hard copy.
I think that you pointing it out that it's been provided in discovery, that's sufficient, so I'll leave it at that. Thank you, Mr. Conley. Mr. Hallman, cross-examination.
I have nothing for the officer, thank you.
Thank you. Mr. Allen,
I have nothing to add.
redirect.
No redirect, Your Honor.
Thank you. May this witness be excused?
Yes, Your Honor.
The objection to the witness being excused, counsel.
No objection.
No objection from you, Your Honor.
Mr. Morosky.
No objection.
Sergeant, you're excused. Thank you for your attendance. Free to go about your business. Or stay.
People have no further proof, Your Honor.
Any proofs, Mr. Morosky?
No proofs at this time, Your Honor.
Mr. Hallman?
None from Mr. Pechette.
Mr. Allen?
And for Ms. Buchholz.
Very well. That will conclude the entry phase of the reopening of proofs And just a moment. I want to confirm that council did receive the order question subpoenas that have been prepared today or yesterday.
Yes, Your Honor.
I received it, Your Honor.
Very well, Mr. Mayor.
I received it this afternoon in the hallway from Mrs. Cook.
All right.
Received your application.
With regard to the files involving Mr. Berry and Ms. Buchholz, the court will take the matters under advisement and issue a written opinion. And the court will confirm that the deadline for counsel or the defense, Mr. Pahani's filed a memo that everyone should have received, correct? That was served on, the court received it on September 27th, right?
Served on the same day to defense counsel, Your Honor.
Okay, so then we agreed the last time the council would have 10 days to respond to that.
Your Honor, our brief, I believe, is due on the 14th.
Okay.
And I would ask the court for some time for us to get the transcript from today, because we will be referring to the record that was made today. So I spoke with Ms. Cook briefly before the hearing. The hearing on volume 1, the August 18th date, should be ready at some point in the next, I think she said a couple of days, and that the other should be ready shortly thereafter. October 14th might be pushing it if we don't get the transcripts shortly.
Understood. I'm going to kind of put Ms. Cook in charge of when she's going to be finished within a reasonable period of time, knowing her other matters she has to do for her work duties. And if she's not going to be able to do it by the 14th, then I'm not going to hold her that day, then she'll contact counsel, we'll set up some additional reasonable time to get the transcripts prepared, reasonable period of time for counsel to review them, and then set a final cutoff date for briefs or memos to be filed again, Buchholz and Berry. With regard to Mr. Pechette, the standard to be applied following the evidentiary phase of the preliminary examination is whether or not the people have provided sufficient evidence as to each element of the alleged offense that Mr. Berry's charged with, which is a home invasion charge, and whether or not there's probable cause to believe, based on the evidence, that there's that the offense was committed, and whether there's probable cause to charge Mr. Pechette. And I find that based upon the evidence submitted at the preliminary examination from the time it began to today, the people have not provided sufficient proof as to that charge. The felony charge against Mr. Pechette is hereby dismissed, and fine will be processed as provided by law. Anything else, Mr. Bonney?
Nothing from the people, Your Honor.
Mr. Marazzi?
Nothing on behalf of Mr. Berry, Your Honor. Thank you.
Mr. Holmes?
Nothing, thank you, Your Honor.
Mr. Allen?
Nothing, Your Honor, thank you.
Very well.